Good morning. I have just finished my chemically breakfast bar and my chemically energy drink. So let's talk about some comments that were made yesterday that I think are worthy of being addressed. Number one is, what is the difference between looking and photography? Neither communicates anything. Why is one speech and the other is not? Well, that's a pretty simple answer. Communication and speech or looking and speaking are two entirely different things. Speaking is just treated by the court differently. Now, if you want to describe something, obviously you have to see it first, but looking at it isn't protected speech. Talking about it, that's when the protection starts. Now, with photography is a little bit different, and I will explain to you in terms that perhaps you may be able to grasp. Imagine that you're going to write a letter to a loved one. You sit down at your desk with your pen and your paper. Have you done anything that is protected by the First Amendment yet? No, you have not. Now you place your pen against the paper and you write the first word. Now have you done anything that's protected by the First Amendment? Yes, you have. Whatever you've just written is protected by the First Amendment because you are intending on communicating that message. Or even you may not even be intending on communicating that message. It might be a letter to a dead relative, but you may end up communicating that later to someone or something. Or it may be that your heirs, that your descendants will someday put that up in a museum or read that to see your state of mind at this point. It is a communicative act. Even though you haven't actually disseminated that information to anybody yet, you may at some point in time do so. The same thing with photography. With photography, you go out and you decide what to take a photograph of. That is picking what you're going to be talking about. It's picking the subject of your letter. You take the picture. You have now written the letter. Whether or not you send the picture/letter, in my analogy, is irrelevant to whether or not that is speech, because you may at some point send it. Courts have used examples like you may not know the value of the picture you took now, but someday there might be greater value to it. A person in the picture might turn out to be famous someday, and it might be a valuable letter or something along those lines. But it is communicative, and it may someday be communicated. So that's the difference between those two things. Somebody else has an issue with the why. Why is the example they used were commercial filming ordinances, where you have to get a permit to shoot commercially. And why is always important in speech. It is always important, not just for photography. Political speech and religious speech have higher levels of protection than commercial speech. And things like child pornography have no protections at all. So the what you're talking about is important to any analysis. Commercial speech they look at commercial speech. It's a 4-prong test. I never really liked the 4-prong test. If I remember correctly, the first step you have to do is determine whether or not it is speech. Whatever the commercial activity is, you have to determine if it is speech. If it is speech, then you have to determine if there is a significant government interest. If there is a significant government interest, then you have to determine whether the regulation directly relates to that significant government interest. And finally, it can't go beyond that significant government interest. That's a four-part test way of saying it has to be a significant government interest and it has to be narrowly tailored. I don't know why they chose to break it out the way they did. I haven't really looked into it very much, but that's the test, or as near as I can remember it. So the hypothetical that was given was pretty silly. I mean, I don't like hypotheticals in general. The hypothetical was, if I wanted to sell dash cam footage and I was going to drive around town with my dash cam footage, is there, would I have to get a permit? Could they enforce it, etc.? And I don't think that is a scenario that is ever likely to happen. But if they were going to enforce it, you would have to run through that test. What is the significant or important interest that the government would have in regulating you with a dash cam? And how would they differentiate the different treatment between you with that dash cam and somebody else with a dash cam? It's just not likely to happen, because as applied, it would most likely fail a constitutional test. So I wouldn't expect it to ever happen that they would go for it. Just imagine what they would have to, the information they would need to know that your dash cam was filming for commercial purposes. I mean, it's just, that's why I don't like hypotheticals. They're pretty silly. And finally, once again, reasonableness. Our good sovereign citizen still doesn't understand why reasonableness isn't a part of the intermediate and strict scrutiny tests. Reasonableness is baked into every law. Every law has to be reasonable. Let me step that one back ever so slightly. Every law that I am aware of that has been challenged has to be reasonable. Now, you see a lot of discussion on reasonableness in Fourth Amendment tests, because the Fourth Amendment specifically states that the Fourth Amendment protects you against unreasonable searches and seizures. So obviously they have to actually talk about it. It's baked into every Fourth Amendment test. But as far as the First Amendment is concerned, it is not a part of intermediate scrutiny or strict scrutiny. Now, there is an element of reasonableness there. If the rule is unreasonable, the court's going to find a reason to get rid of it. But it's not, reasonableness is not a separate element of the test. They're looking at reasonableness in those particular categories that they're looking at, but reasonableness is not in itself a test, except for the non-public forum analysis. That's the only place where all the court is looking at is reasonableness. That's it. There is no other narrowly tailored. There's nothing else the court has to look at other than, is this reasonable and is this viewpoint neutral? It is, reasonableness is the test in non-public forum analysis. Reasonableness is a part of the components of the other ones, but it's not in itself the test. So if you're talking about a reasonableness test, you're talking about non-public forums. Again, words matter. And if you don't understand the words, don't argue with me when I'm telling you what the words mean. You could look at the tests. He cited to some Supreme Court case that was a mixture of First Amendment and 14th Amendment equal protection analysis that said, basically in an offhanded way, the courts have always allowed reasonable time, place, and manner tests. And then it cited to Cox, or Louisiana v. Cox, and a few other cases, none of which included reasonableness into their test. And if you look at Ward versus Rock against racism, there is no reasonableness portion of that test. Like a specific portion of the test, it's reasonableness. So if you want to say that this particular statute is unreasonable, that's fine. I answered a lot of questions, a lot of my final exam questions in law school. I remember I answered a lot of stuff about, or I said, is this reasonable? I always did a reasonableness analysis in there, because most laws have a component where if it's not reasonable, the court's going to find a reason not to enforce it. But that doesn't mean that the specific test has a reasonableness element specific in it. So I hope that makes sense. Again, I don't believe that Too Dumb for Lawyer really should be giving advice in my comments, yet he persists in doing so. It is a free country, and I'm not going to ban him or block him from doing it, but I just, again, want to caution everybody that he is not a lawyer. He is a liar, and he's a sovereign citizen. He doesn't understand what he's talking about, and you should not listen to his advice. Seek a qualified, competent local attorney. It doesn't have to be me. I'm not asking you to trust me. Go talk to an attorney. Pay an attorney to do some research on it. Don't just get his first impressions. Pay him to do the research on it. put money behind it. That way he's got a stake in the game. Anyway, thanks for watching. Have a great morning.